The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business for the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
All right. Good morning, everyone. We're pleased to have you here. Mr. Hazelwood, when you're ready, we'll begin with our first case, United States v. Slate. Please proceed.
Thank you, Your Honor. Good morning, and may it please the court. Benjamin Hazelwood for William Slate. This court should reverse the district court's sentence for two reasons. First, the district court imposed a 40-year sentence on Mr. Slate in violation of his Sixth Amendment rights under Apprendi versus New Jersey. This court's decisions in Chambers, Collington, and Lancaster dictate that the district court should apply intervening law in conducting a First Step Act resentencing. Had the district court done so, it could not have sentenced Mr. Slate to a term of more than 20 years because the jury in his case did not make any drug quantity finding whatsoever. Second, the district court did not consider over 20 years of post-sentencing facts that Mr. Slate submitted regarding his rehabilitation in prison, his health conditions, and his support network outside of prison where he released. The district court conducted this sentencing prior to this court's decision in Chambers, and so therefore did not have the benefit of the decisions on that topic that have come down.
Did Chambers and Collington and Lancaster mention Apprendi?
No, Your Honor. Chambers and Lancaster dealt with intervening legal developments related to the sentencing guidelines.
I understand, but there's no, I understand that, but there's no specific discussion of Apprendi in those cases.
That's correct, Your Honor. We would submit that application of Apprendi flows from the court's holdings in those cases. If anything, Your Honor, application of Apprendi is more straightforward and I think an easier case than application of the intervening sentencing guidelines issues that were raised there. As Your Honor said in Your Honor's dissent in the Lancaster case, there's a disagreement as to the scope of legal issues that may be considered in a First Step Act resentencing. I think everyone agrees, however, that if a district court like this one exercises its discretion to impose a reduced sentence, it applies the new statutory sentencing ranges from the Fair Sentencing Act. Apprendi, unlike the career offender guidelines, tells the district court precisely how to do that in 2019.
Mr. Hazelwood, I'm sorry, Judge Wilkinson, you just said something that I wanted to ask you about. You said if the district court exercises its discretion to apply the First Step Act and reduce the sentence, there are a couple of procedural requirements for First Step Act eligibility, and once you get past those hurdles, it seems to me that if, under your position, as it appears to be the case here, if a particular changing guidelines range, or in this case, a change in the law, Apprendi, which is not retroactive, but apparently that doesn't seem to matter here, at least that's your position, changes the statutory maximum, it seems like the district court has no discretion, that it must at a minimum reduce the sentence to that sentence, the new statutory maximum. Is that your position?
Your Honor, two responses there. One, I think, is specific to the facts of this case, and one more broad. This case is unique because, unlike in Collington, the district court that did exercise discretion and did impose.
You're breaking up a little bit on me.
My apologies, Your Honor. Is that better?
That's better.
In this case, we have a district court that did exercise its discretion, did impose a reduced sentence on Mr. Slate. So even if a different case would come out differently in which a district court had refused entirely to impose a reduced sentence, this is a unique case because the district court has already done so. And so the question is, can it impose that reduced sentence without?
No, but let me I think follow up on Judge Diaz's question. The hard thing, the difficult thing for me to get around is this very specific language in 404C, which says nothing in this section shall be construed to require a court to reduce any sentence pursuant to this section. And if we hold that Apprendi is mandatory, then aren't we essentially overriding what Congress said in 404C about we're requiring the district court essentially to reduce the sentence, and wouldn't that fly in the face of Congress?
No, Your Honor. I think this court addressed that issue in the Collington decision. That was a decision where the district court had exercised its discretion not to resentence at all, and this court held that it was an abuse of that discretion in that case where the new application of the new statutory sentencing ranges would have required.
Yes, but that wasn't an Apprendi case. I mean, this seems to me to fly, or the concern I have is that it seems to just fly in the teeth of that particular proviso. And I'm thinking that I'm wondering, maybe Apprendi is something that the district court can, in its discretion, consider, but to go beyond that and say it's required seems to me to take on Congress. There's a difference. I mean, what's wrong with a situation where it's discretionary with the district court whether to consider Apprendi, but it's not absolutely mandated?
Well, Your Honor, I would first note that even under that rule, Mr. Slate would win this appeal because the district court did not consider Apprendi in his particular.
Well, it could or it could not. It wouldn't be necessarily an error. It would not be an error not to consider Apprendi because that comes close to requiring it. But the district court's discretion, it seems to me, in this kind of proceeding is about as broad as it gets.
Well, Your Honor, even under a may consider rule, I would point the court to the DC Circuit's decision in United States versus White. We cited that one in our reply brief. It had come down, I think, while the case was being briefed. The DC Circuit applied a may consider Apprendi rule, but still remanded for the district court have the benefit of ruling that it could.
Well, what you'd like is this thing to be remanded and have the district court take a full look at it again.
Well, at minimum, if the court were to find that Apprendi may be considered, we would submit again that.
Well, but the district court hadn't ruled on Apprendi yet, has it? Why wouldn't we let it take first crack at it?
That's correct, Your Honor. We would submit that.
Now, we on last Friday, I think it was, or Thursday, we issued a unpublished opinion, similar to Donaldson or Nicholson or something like that. Have you seen that one?
I believe so, Your Honor. The last name of the defendant is escaping, but I believe so.
And we mentioned those three cases that you talked about, Chambers and Collington and whatever the other one is.
Yes, Lancaster, Your Honor.
And told the district court to take another look at it. Is there any material difference between this case and that unpublished case that came out last week?
Well, yes, Your Honor, because we would argue that Chambers and Lancaster require the application of intervening law, and Apprendi is intervening law here. And so,
well, we told the court in that unpublished case to take a look at Chambers and Lancaster. We specifically named them.
Yes, Your Honor, and we would. My apologies.
Isn't there some?
That's what I'm saying. Is there any material difference between this case and that one?
Yes, because if the court rules in our favor as to the application of Apprendi, the district could not impose a sentence of more than 20 years. To the extent the district court disagreed with Mr. Slate's Apprendi argument, it would be back to this court.
Why wouldn't it be? This is a pure question of the law. Why wouldn't it be advisable for this court to give guidance on whether Apprendi is required to apply to these First Step Act proceedings, rather than have the case yo-yo back and forth. Might be better to decide it now. Another thing that concerns me is how this how this question comports with United States v. Dillon, where the Supreme Court declined to hold Booker retroactive in a 3582C2 proceeding. And it seems to me the principles were pretty much the same. And the Supreme Court says in Dillon, 3582C2 represents a congressional act of lenity intended to give prisoners the benefit of later enacted adjustments, which, quote, does not implicate the Sixth Amendment right to have essential facts found by a jury beyond a reasonable doubt. Now, I don't understand why, if we had some sort of ruling that Apprendi was required or mandatory, aren't we crowding Congress in what it said in 404C, and aren't we going to be, to put it gently, in some tension with the Supreme Court's decision in Dillon?
No, Your Honor. I think this court has considered both the 3582C question and the Dillon question. As far back as Worsing, the court has made clear First Step Act proceedings are not simply a mechanical reduction as the Dillon involved or as 3582 involved. They arise under 3582C1B. And as the court put it in Collington, the district court is not conducting a complete plenary resentencing, but is doing something more than a mechanical reduction. And the limitations of Dillon.
I mean, Dillon and this case have a good deal in common in this sense that they were both acts of Congress which were directed at particular cohorts of offenses or particular offenses and particular class of offenders. And Apprendi is something that applies across the board in initial sentencing proceedings that everyone is entitled to at the end of a trial or a guilty plea or whatever that first proceeding. But both the First Step Act and 3582C indicated Congress's desire to correct a specific problem that pertained to certain covered offenses. And if we say that regardless of Congress's sort of limited focus, that every time Congress enacts a targeted sentence reform, it's no matter what Congress says, it's going to carry Apprendi and all the full accoutrements of the Sixth Amendment. It seems to me we are impairing Congress's ability, which we would all want, to enact limited sentencing reforms that don't bring about everything that is applied in a plenary initial sentencing. And Collington and other cases indicate that even these First Step Acts, I think Collington says, they're not plenary proceedings. The defendant is not there. The defendant is not there in person. They're very different from the context in which Apprendi was applied, which was the plenary initial proceeding to which everyone is entitled. This is a different species, it seems to me, and I'm worried about going up against Section 404C and also against the Supreme Court's decision in Dillon, which seems to map on to this decision to a pretty significant extent.
Your Honor, I think briefly the answer to the court's concern is that we're not talking about two poles here. I think there are proceedings as in Dillon or as under 3582 that are limited sentence reduction proceedings, subject to the limitations Your Honor just said. There are, of course, initial sentencings with which I think as this court has interpreted the First Step Act, what Congress meant for these particular proceedings was something in the middle. And that something in the middle, it entails the imposition of a new, I think that's what the court said in Chambers and subsequent decisions. Here, at minimum, when imposing that new sentence, the district court has to look at the rules for applying a new statute.
Say that again.
At minimum, when the district court is imposing a new sentence under the First Step Act, it has to look at application of the new statutory sentencing ranges. And in doing that very narrow...
And the new sentence can't exceed the statutory maximum.
Cannot
correct?
Exceed the statutory maximum under Collington.
And Chambers and Collington stand for that proposition, right?
Correct, Your Honor. That
So
limited...
the court has to figure out what the statutory maximum is.
Exactly. And
you say here it's no more than, you say no more than 20 years.
Correct. Apprendi tells the district court in 2019 how to apply those statutory maximum sentences.
How come you don't say that it's no more than 5 years?
Because the statutory maximum applicable to count one for Mr. Slate with the jury's finding of no specific quantity would be 20.
Well, but under our old Quixie case, when you got these multiple objects of a conspiracy and they get a general verdict, and you got marijuana mixed up with cocaine, and they don't say what was what and what the quantities were, like you have here, the government stuck with the least punishable.
Correct, Your Honor.
And that would be 5 years.
Your Honor, I believe that
But you don't argue that.
I believe that under Quixie, the same 20-year statutory maximum would apply. The sentence on count one.
Well, there's no 20-year maximum for marijuana, is there?
My understanding, Your Honor, would be that the conspiracy under 846 would still fall into the 20-year statutory maximum.
Well, you'd have to say that it's cocaine rather than marijuana.
Yes, Your Honor.
They proved a lot of cocaine. They did because they convicted him of some cocaine on some substantive counts, but on the conspiracy count, they didn't have anything found by the jury except guilty or not guilty. And they left marijuana in it for purposes of the conspiracy count.
We agree, Your Honor.
But if you take that view, aren't you creating a pretty stark disparity because you're producing a windfall for a defendant's sentence before Apprendi when prosecutors felt no need to have jury findings on drug quantities, and those we're setting up a very different sentencing regime for defendants sentenced before Apprendi and those sentenced afterwards. And that's part of the problem, is that your interpretation builds into the whole sentencing equation a significant inequity.
Your Honor, I have two responses there. The first is that is what Congress did in the First Step. It chose a somewhat extraordinary step to disturb the finality of crack cocaine sentences for defendants, because the disparity under which they were sentenced was dark. And so inevitably, Mr. Slate is getting a windfall as compared to a defendant who did not obtain a First Step Act resentencing. And
well, you're not getting a windfall if you're sentenced pursuant to the statute that applies. I mean, it might be a windfall compared to what to a 40-year sentence or a life sentence, but if the statute puts a maximum on it of 20 years or 5 years, that's the law. And
precisely,
we have to apply the law.
Precisely, Your Honor.
We're not here to to decide what the fair sentence is.
Precisely, Your Honor, and Mr. Slate's Sixth Amendment rights under
It has a lid on it that the Congress put on it.
Correct. Congress dictated that defendants could obtain the imposition of a new sentence.
Mr. Hazelwood, can I follow up? Because early on you mentioned this court's cases, Chambers and Collington, and in particular Lancaster, and I want to make sure I understand what your position here is. Obviously, you'll take what you can get, but as I understand it, your position is that under our court's cases, retroactivity really doesn't play a role in how a district court decides to fix what the maximum sentence should be. And in Lancaster, for example, there was the panel majority decided that a change in the law with respect to career offender status with no hint as to retroactivity was something that the district court had to consider, and it erred in considering it, and so we sent the case back. And so if that's that's sort of our jurisprudence as it now stands, don't our cases essentially compel the application of Apprendi under these circumstances?
Yes, Your Honor, and I think as Judge Wilkinson pointed out in his dissent in Lancaster, the sentencing guideline change.
Well, you actually concurred reluctantly.
Yes. Apologies for mischaracterizing. Concurred. The sentencing guideline change was not a retroactive change there, and yet the application that was compelled. So we would submit that application of Apprendi is required under that. I think the court can also look at Apprendi as a more fundamental and more core issue. In 2019, the district court was, under this court's precedence, imposing a new sentence, and at minimum, if nothing else, applying the new statutory sentencing range. Apprendi, and as Judge King has pointed out, Quixie, or this court's interpretation of Quixie and Rhines, it tells district courts how to impose sentences in these particular cases. And so the court could narrowly require district courts, when they are imposing sentences in that way, to follow the existing law as the date of sentencing for that narrow application without necessarily requiring the application of all retroactive or non-retroactive legal change.
All right. Are there any further questions? Judge King, Judge Diaz, do you have further questions?
No, Judge Wilkinson, thank you.
Thank you very much. Mr. Cook, are you ready?
Yes, Your Honor. May it please the court. Collington did not specify in any respect how a court would go about determining what the applicable statutory maximum is in a Section 404 case. And in this case, even if the court were to, under Collington, deem that you had to apply Apprendi, it would still be the case that this sentence should be affirmed, and you can reach that through a number of different routes. One would be to say, this was obviously a 50-gram crack conspiracy. That's the only way you got to the life maximum in this case. And 50 grams exceeds 280 grams or 28 grams, which is the next lower penalty range. And so necessarily, this case has to be deemed to be a 5 to 40 type statutory penalty range. Now,
but you had a general verdict, Mr. Cook. You all got a general verdict. You asked for one, and you got a general verdict, and you're stuck with it. Yeah.
Respectfully, Your Honor, if this case were on direct appeal and you were applying the full panoply of Apprendi and other rights, you would conduct, under cases like Greer and Skilling, a harmlessness analysis and evaluate whether or not the jury would have found more than 28 grams. And here, the jury would have.
But you don't raise a harmlessness position in your brief in this case.
I do, Your Honor, respectfully.
Well, I looked at it before we got on here, and I didn't find it. But anyway, I was going to ask you if you were obliged to consider harmlessness anyway. You haven't raised it, or if you can raise it now. I mean, Rule 52 may give you a right to it anyway. But anyway,
I've raised harmlessness.
But you want to fall back on harmlessness, that's fine. Go ahead.
That's simply one way. I mean, the lead position, the United States' position is that Collington is wrong. There's no compelled sentence reduction in this case. That was the Solicitor General's position. And
Hold on a second, Mr. Cook. If what you're telling us is that Collington is wrong, we're kind of stuck with Collington, aren't we, as a panel?
You are. I'm just preserving the United States' position for further review and making clear
you say
that we don't agree with it.
You say the Solicitor General has determined it's wrong?
Yes, if you look at the briefing and the argument in Terry, which was after Collington, although Collington isn't specifically named, the United States took the position that every sentence reduction is discretionary, and indeed defense counsel and Terry conceded that that was correct. And
we don't have to agree with positions taken by the Solicitor General in other cases or other courts.
No, that's certainly true, and I'm simply preserving the United States' position.
We have to follow our own precedent.
I don't disagree with that.
Well, now, you can take Collington to the Supreme Court and try to get it fixed if you all think it's wrong. You can do that, but we have to follow it, don't we?
Yes, Your Honor.
And so do you have to be. You're bound by also in this appeal. You're not bound by what the Solicitor General said. You're bound by what we said.
I have to adhere to the United States' nationwide position, recognizing that this court's opinion in Collington is precedential. So what I'm saying is that we disagree.
So you're trying to talk out of both sides of your mouth, and I don't think you. And I think you know better. You've been around here a long time.
Respectfully, Your Honor, I'm not speaking out of both sides of my mouth. I am saying that the United States' position, which is a nationwide position, is that Collington is erroneous. There is no mandatory sentence reduction under 404. But recognizing that this court has said in Collington that there is, what's on the table here is frankly an expansion of Collington. Collington did not tell courts how to go about determining what the applicable statutory maximum is. The defendant's view is absent.
Well, if you calculate the guidelines, you always have to determine the statutory maximum, don't you?
You do, but then the question becomes, how do you figure out in a case like this what the applicable statutory maximum is? And
well, you look at the record. You look at the record, and you look at the charge, and you look at the verdict.
If you look at the record in this case, it is more than a
Mr. Cook,
you look at the charge, and you look at the verdict, and you look at the statute.
There was no discussion in Collington or in Chambers or Lancaster or anything. The word apprendi and whether it and its applicability was never addressed in any of those three cases.
That's true.
It just didn't come up. Now, would you object to remanding the case to the district court under a set of instructions that you may consider apprendi if you wish, but you're not required to? It's not mandatory, it's discretionary with the district court, and that also in connection with that you can consider the post conviction conduct and the defendant's post conviction record while incarcerated, and just put it back within the district court and saying it is all within your discretion as to how to weigh the defendant's rehabilitative conduct, and it's within your discretion as to whether you wish to consider apprendi or whether you don't. It's not mandatory, it's discretionary, which is what the whole purpose of the First Step Act is. Now, is that something to which you would object?
I think the court could do that, and that would not be a ruling that would, really, I think, aggrieve the government very much. Having said that, as I understand the defendant's position, and let me add one important qualifier. The qualifier would be that the court would still have discretion to impose the existing 40-year sentence. Now,
what I'm doing is I'm simply asking you.
The defendants in this case actually would quite.
Excuse me, Mr. Cook, maybe we're having some trouble, but
yes.
What is wrong with saying that the basic purpose of 404C is to give the district court wide discretion with respect to sentencing, and embedded within that discretion is the ability to consider or not to consider Apprendi, and the ability to weigh the defendant's conduct and rehabilitative efforts while incarcerated. What's wrong with just returning it to the discretion of the district court? I'm not sure that it would sway the district court, because the 5 offenses in this case were committed while the defendant was on parole. I mean, the facts are just not good. And but the point is, why not just send it back to square one? Apprendi's discretionary, and you've got to weigh in the balance in the exercise of your discretion the conduct and rehabilitative efforts while incarcerated. What's wrong with that?
That's fine, as long as the district court has the ability to impose a 40-year sentence. And I think that's where the district court.
How does the district court have the discretion to exceed a statutory maximum in any case, in any event?
In this case, the statutory maximum would remain a 40-year at a minimum sentence, because
that's your position. That has to be your position, that that's what the law is. But
right.
There's no discretion. There's no discretion in any court to impose a sentence that exceeds a statutory maximum. And if a statutory maximum is 20 years, it can't be exceeded. If it's 5 years, it can't be exceeded. If it's 10 years, it can't be exceeded. You can only impose a 40-year sentence if it determines, as a legal matter, that the statutory maximum is 40 years or more. Now, you have to agree with that. And the government has to agree with that. And the Solicitor General has to agree with that.
We agree that you don't impose sentences above the statutory maximum. But the sentence is not on appeal. The position of the other side on appeal is that there's a statutory maximum of 20 years. Right.
That's what they say. And what's that?
I said that's true, and that's incorrect.
I know, but I said their position is that. Their position is that. You disagree with it, but you argue even if, I think in your brief, and you say you're arguing harmless error also.
But that business about the statutory maximum is assuming the very question that is before us today, and that is whether Apprendi applies. That's the problem. The question I have, and that I've asked Mr. Hazelwood, is the tension that I perceive between this case and United States v. Dillon. And, with all respect to Chambers and Collington, they don't have the authority to undermine or erode the Dillon decision. And the Supreme Court in Dillon could easily have applied Booker retroactively and said, no, it's a violation of Sixth Amendment rights. And they said, no, the 3582 sentencing proceeding is dramatically different from the sentencing at the end of a conviction or a guilty plea, the initial sentencing to which every defendant is entitled. And they're saying in these limited proceedings, in this and in both Dillon and in our case, they're limited proceedings. They're not plenary. The defendant's appearance is not required. And Collington makes clear, it says, these are not plenary proceedings. So I have a problem with the tension between this case and Dillon, and whether we are impairing significantly the ability of Congress to act targeted sentencing reforms that reach particular classes of offenders without throwing it open to everything. If every targeted sentencing reform is going to become a plenary sentencing, then you've, I think, reduced the ability of Congress to act and reduce the desire of Congress to act. But are those concerns ones that you share?
Yes, and one thing I do not want to have lost in this discussion is the way in which the defendant's argument would require this court to go farther in a very important way than Collington. On the defendant's view, they're never post, Section 404 is a pre-2010 crack case that falls under 841B1A. On the defendant's view, there's never a 10 to life case because the jury will have never made a finding about 280 grams. And so on his view, the operation of Section 404 eliminates an entire subsection effectively of the statute. And not only is that impossible to square with 404C's language, but even beyond that, it's accepting Apprendi as a rule that must be applied in these cases. It is leading you to completely omit the type of harmlessness analysis that the Supreme Court.
But even beyond the harmlessness analysis, and even beyond the inconsistency with Congress's explicit directions that nothing shall be construed to require a court to reduce any sentence, isn't there a tension between this case and Dillon if we were to adopt Mr. Hazelwood's view?
Yes, I mean, let me also speak directly to Dillon. Dillon stands for the proposition that sentence reductions only do not trigger Fifth and Sixth Amendment problems. You can read Dillon as having been limited somehow to retroactive guideline amendments, but I don't think that's a correct reading of the statute. And logically, it makes no sense that a statute that provides only for sentence reductions on final sentences would somehow trigger a Fifth and Sixth Amendment problem about increasing penalties. It's only a sentence reduction, so it can't be a Fifth and Sixth Amendment problem. Courts have sometimes said, well, look, I know it's not constitutionally compelled in these sentence reduction contexts to apply these Fifth and Sixth Amendment principles, but a court in the district judge's discretion could look at a case and say, you know what, if this case were prosecuted today, it would be a lower penalty, so I'm going to reduce the sentence. And indeed, I would submit that's exactly what happened in this case. The district judge said, you know what, when we sentenced this case, it was treated as 218 grams. 218 grams does not exceed 280 grams. So I'm not going to leave in place the life sentence. I'm going to reduce this to the 5 to 40 range because 218 grams exceeds the new 28 gram threshold in the Fair Sentencing Act. That's perfectly reasonable and appropriate. Indeed, the United States supported that kind of a reduction in this case down to the 5 to 40 range. What the defendant wants is even more. He wants this to be deemed a 0 to 20 case, and that can't be under the Fifth and Sixth Amendments as Dillon holds. But even as a matter of how a court in evaluating a discretionary reduction should go about things, I think it is appropriate to say, look, this was a final judgment that treated this as a 50 gram case. 50 grams exceeds 280 grams, so it easily meets the 5 to 40 range. If you look at the facts, it's at least 218 gram case. And if you went to harmlessness analysis, you would say that this is a case where the drug quantity exceeds the 28 grams easily. And also, there's also the point that there are multiple counts here and you could stack statutory penalties as this court
But you have no, as a bottom line for your position, you have no objection to a remand to have the district court decide whether or not it wants to be instructed by Apprendi, that it can be instructed by Apprendi if it wishes, or it need not be instructed by Apprendi as it wishes. I mean, even the guidelines imply, have a large element of discretion in them. The fact that the guideline range doesn't tie the district court can downwardly depart, the district court can upwardly vary. It doesn't. And if even if the guidelines themselves compare district, how can Apprendi impair the district court's discretion, because these 404C proceedings were intended by Congress to provide the widest range of discretion at all. Maybe the district court wants to calculate the statutory maximum and everything, but that's only one step. The second step is whether Apprendi applies once that calculation is made. And that's got to be within the district court's discretion. And what we're trying to do, it's counter to the guidelines and counter to Section 404C, is take a discretionary section that Congress passed, a statutory section, and convert it into something mandatory. And that just seems to me to turn congressional intent right on its head. You see what I'm saying?
Yes, Your Honor, and I agree with that. We don't oppose a remand provided that the remand leaves the district court the discretion to leave in place the 40-year sentence.
Mr. Cook, can I ask? So let me ask about that, because there's a lot to commend the concerns that Judge Wilkinson has raised, but I keep going back to Lancaster, and it would seem odd that we would suggest in this case that the district court would have discretion whether or not to apply Apprendi, when we said in Lancaster that the court had no discretion in applying a change in the law with respect to non-retroactive guideline facts. So, I mean, how do you square that case, other than to say that you disagree with it? I think maybe that's the fundamental answer that you might have. But aren't we bound by, even though, and it's true, Lancaster said nothing about Apprendi, but it would seem odd that we would say in this case that a court has discretion whether or not to consider Apprendi, having said in Lancaster that a court has no discretion whether or not to consider non-retroactive guideline changes in the law when deciding whether or not to grant First Step Act relief.
Right. As a threshold matter, we do disagree with that line of precedent, but taking it as given, I think you can make a couple of points about it. The first would be that Apprendi is talking about criminal liability here, and that puts it in a different category. Everything we're talking about here under 3582 C1B and 404 is about sentence reductions, not changes in criminal liability. The second point I would make is, even if you treat it as something a district judge has to apply, you still should be doing some sort of review of the record about what the evidence would support in this case, so that you don't end up in a situation where you've said there are literally no B1A offenses for crack anymore under Section 404, which... So
that's the harmlessness analysis that you're talking about?
Right.
Okay.
If you don't do that, then I think you've taken this to a very extreme position. And I see my time is up. I don't want to wear out my welcome.
I've got a question too.
Go ahead and finish your sentence. Go ahead and finish your sentence.
But I think Judge King had a question.
I didn't want to interrupt you, Mr. Cook. I thought you were still speaking. I'm sorry. Is it your position that all the counts on which this defendant was convicted for the court in this proceeding, or is this relate to count one, the sentence on count one?
Only count one is a covered offense. I'm not sure I am following what Your Honor's question is. Could
Well,
you?
you talk about the harmlessness. You said
Right.
earlier in response to one of the other judges that something about your harmlessness argument took into account the other offenses and the sentences on the other counts.
Right.
And
Now,
and potential for stacking.
yeah,
So-
let me.
But that's what, and that gives rise to the question, you're taking the position that these other counts are before this court now. Are you? You're not.
So there's two ways of looking at that. Way number one is to say that under the as if language in 404B, if you were to take this case and imagine that the Fair Sentencing Act applied at the time of sentencing, then under 5G 1.2D, the guideline range would be life still, and the court would stack counts to get to the guideline range. And so this defendant would end up with at least a 40-year sentence, in fact, more. So there's that way of looking at 404B. Another way of looking at this, which this court has not said in any case that I'm aware of, is that you can only make a change to the sentence on a covered offense. Some other courts have said that. This court has not. That issue has not been briefed in this case. It doesn't seem like an outcome this court is likely to endorse, but the court could say that only sentences on covered offenses can be changed.
Is it your?
Well, Mr. Cook, excuse me, Judge King, I interrupted you. Go ahead.
No, you go ahead. You go ahead, Judge Wilkins.
I was just saying you can have a mandatory feature to these proceedings in the sense that it's mandatory to recalculate a guidelines range, or it's mandatory to find out what the statutory maximum would be. But the fact that it is mandatory to consult the record as to what the sentencing statutory maximum may be, and it may be mandatory to take into account as to whether it was a judicial finding or whether it was a jury finding. But the fact that recalculating the guidelines range and finding what the statutory maximum is, that's step one. But that doesn't get you all the way home, because even after you've recalculated the guidelines and even after you've discovered what the statutory maximum for this count or that count is, you still retain the discretion as to whether to impose a new sentence within the guidelines range, or whether to have Apprendi applied all. And if the district court were to say, yes, this is a statutory maximum, I realize that the judge has imposed it, but looking at the whole picture here, these were horrendous offenses. They were committed while on parole. I'm just not going to reduce the sentence. Now, the district court in this case did, but the question I'm asking you is, finding statutory maximums and finding guideline ranges doesn't render 404C inapplicable. It doesn't strip the district court of all, Apprendi doesn't strip the district court of all discretion in this context any more than finding the guidelines strip the district court's discretion to depart upward or downward or whatever. You've got to read that language seriously. At the end of the day, when the sun sets, the district court retains discretion over whether to order a reduction. And I don't see any way around it.
We agree with that, Your Honor.
So you
Mr.
agree?
Cook, the problem.
It's
Sorry,
your
Judge
position, Mr. Cook, the government's position is that the district court can exceed impose a sentence or ratify a sentence that exceeds the statutory maximum.
No, the government's position is there's a final judgment of conviction with a valid sentence here, and Congress enacted a mechanism for discretionary sentence reductions.
So, if on the review pursuant to Collington, the statutory maximum is determined to be 20 years, for example, that can be exceeded.
I think that if you were to look at what the DC Circuit did in White, or what the Sixth Circuit did in Maxwell, or what the 11th Circuit has said, you would find that in all of those cases, those courts aren't saying that sentence reductions are mandatory.
And let me ask you, I wanted to get a question about those other counts. Am I wrong that the sentences on the other counts as to this defendant have been served completely?
He has served more than 20 years, but under this court's opinion in Smith, there's a unitary sentence.
Answer that first, yes or no. Has he served the sentences? They were imposed in a concurrent manner, correct?
Right, but it's a unitary sentence, which this court discussed that principle in Smith.
But the sentences on the other counts on which he was convicted have been served. He served 23 already, right? Approximately.
Right. But it's a unitary sentence. And what this court said in Smith is that you can reconfigure components of a unitary sentence. The other point is, unlike in Smith, you're talking about, once again, a discretionary sentence reduction under 3582C1B. And I don't think that the kinds of double jeopardy concerns at issue in Smith really come up in a context where all you were talking about is a discretionary sentence reduction.
All right, let's conclude unless there are further questions. Judge Diaz, do you have some further questions of Mr. Cook?
I don't, thank you.
Judge King, do you have any further questions of Mr. Cook?
I do not.
All right. Mr. Hazelwood, you have some time in rebuttal, and we'd like to hear from you.
Thank you, Judge Wilkinson. If I could begin with the stacking harmless error point that the court was just discussing. Judge King, as you recognized, the only harmless error argument the government made in its brief was this idea that in 2019, imposing a new sentence on Mr. Slate, the district court could have reopened his fully served prison terms on other counts, which Mr. Cook said a moment ago are not covered by the First Step Act, and imposed an increased sentence on those counts by making them become consecutive rather than concurrent sentences. That flies in the face of the way that the government has tried to limit the scope of the First Step Act in every other case this court has heard, and in this case. So even putting the double jeopardy concerns aside, which are real for the reasons we briefed, there is no conception of the First Step Act that would allow a district court to reach out, reopen fully served prison terms, and increase the sentences on those terms. To the extent that Mr. Cook is nodding at another possible harmless error argument, which I take from his discussion of the 50 grams in the indictment and things of that nature, we cited the court to a case in our letter. Mr. Cook submitted a letter last week that seemed to be hinting at other possible harmless error arguments that hadn't been briefed.
When you're talking, Mr. Hazelwood, about sentencing increases, that brings up another concern I have, and that is that the Apprendi, the First Step Act and 3582C2 were both enactments that were designed to stimulate sentencing reductions in a worthy case. We know that. And Apprendi has a different focus, and in fact, it goes in the opposite direction, because Apprendi is not concerned with sentencing reductions necessarily. It is concerned with avoiding unwarranted sentencing enhancements based on judicial findings. But if you look at in which way the arrows point, isn't there a difference between statutory sections, which are targeted sentencing reductions, and Apprendi, which is focused on avoiding sentencing increases and enhancements? Those are not differences of degree, are they? They're differences in kind.
No, Your Honor, I agree that there are those two categories. I disagree that First Step Act proceedings fall into the sentence reduction category for the simple reason that, as this court said in Worsing, as this court said in Chambers, when a district court, as here, exercises its discretion, it is imposing a new sentence. And that is something different than a mechanical reduction under 3582C2 and under Dillon. Judge Wilkinson, I recognize we may disagree on that, but I think that's an important point that this court has addressed, that a First Step Act proceeding is the imposition of a new sentence. And so when a district court sits down—
Why did Collington say this is not a plenary sentencing proceeding? I mean, that language is in there, and I don't know all the different ways it's not a plenary sentencing proceeding, but one of the crucial ways is that the presence of the defendant, as I understand it, is not required. And so there's got to be a big difference between the sentence which one is entitled to, really as a matter of constitutional right, on the heels of that initial sentence, on the heels of a conviction or on the heels of a guilty plea, on the one hand, and a sentence which is a matter of congressional grace and lenity, as the Supreme Court pointed out was the case in Dillon. The long-range consequences of this are going to be deleterious from the standpoint of criminal defendants, because people in Congress are going to say, look, when we try to pass targeted sentencing reductions, what's happened is that the courts have transformed them into plenary sentencings and a whole new sentencing. And district judges are going to be clobbered by that. They already are being clobbered by it. But sometimes you need to be just a bit careful about what you wish for.
Your Honor, a few points in response. The first, on the plenary resentencing point, Mr. Slate is not advocating for a plenary resentencing for a number of reasons. I see that my time is up, but if I may finish.
No, we gave Mr. Cook some extra time. You deserve some too.
Thank you, Your Honor.
I've got another question, Judge Wilkinson.
Yeah, Judge King has a question for you, Mr. Hazelwood.
Yeah, sure. Mr. Hazelwood, you all raised a question about the fact he didn't have counsel in the earlier proceedings. And of course, when he came up here on appeal, we not only gave him counsel, we appointed one of the finest law firms in the world, and we have you here today. If this thing were to go back to the district court, are you fellows going to stick with him?
Your Honor, as the court knows, we were appointed under the Criminal Justice Act, and we will absolutely fulfill the terms of that appointment for Mr. Slate.
Does that mean you're going to stick with him?
Your Honor, I'm not in a position to commit to.
My question.
I apologize, Your Honor. My authority.
I practiced law for a little while myself, and I thought lawyers get a case, and unless they're conflicted out or something, particularly in a criminal case, they stick with their client.
Yes, Your Honor. I'm not familiar with the specific terms of the scope of the CJA appointment. I don't want to commit to something that we haven't, that might be beyond the scope of an engagement letter at this particular point in time. I apologize, but my answer is.
Well, I'm not satisfied with your answer. If that's your answer, you can settle with it.
If I may, Judge Wilkinson, we were talking about a plenary resentencing. I'd like to answer your question there.
No, please proceed. Sure, be happy to have you do that.
Mr. Slate is not advocating for a plenary resentencing for a number of reasons. As Your Honor stated, Mr. Slate is not suggesting he has a right to presence or allocution. And I think, again, I would encourage the court to look at Collington and how Collington discussed the spectrum between mechanical sentence reduction proceedings, which this is not, as this court has held, and initial plenary resentencings, which again, this is not. The first step back.
You're inching toward plenary resentencing, case after case after case. These proceedings are becoming more and more and more elaborate. And you talk about it not being a mechanical exercise, about it being a discretionary exercise. And yet you're meeting yourself going and coming, because it's that very discretionary exercise that you're leaning upon now, that with the other hand, you're trying to limit and turn it into a mandatory application of Apprendi. You're trying to say, well, this is different from 3582C2 because this is a discretionary exercise. And then in the same argument, you're saying, no, it's actually mandatory that Apprendi applies, and you don't have any discretion at all. And I don't understand that. It just seems to me you're meeting yourself going and coming with that.
I think I may have misspoken. We submit that First Step Back proceedings are not equivalent to Dillon or 3582C2, not because of any discretion, but because Congress, as this court interpreted in Worsing and Chambers, specifically chose to direct district courts to impose a new sentence, which carries with it much more than a mechanical reduction. So that's our position as to why this is different than.
But imposing a new sentence is different from imposing a reduced sentence, and that is what Congress did not authorize. It did not. It authorized it. It did not require it.
Well, I think as this court put it in Collington, a First Step Back proceeding can result in the imposition of a new reduced sentence, and so imposing a sentence is something more than a sentence reduction. It's not a plenary resentencing. The defendant, as I said, and as Your Honor said, doesn't have a right to presence or allocution. Mr. Slate is not suggesting that he could reopen any factual disputes that were litigated at the initial sentencing. What he is saying is that when the district court sat down in 2019, exercised its discretion to impose a reduced sentence, it had to apply the statutory sentencing ranges, and Apprendi, or as Judge King has mentioned, Quixie and Rines, tell the district court how to do that. And so I would disagree with Your Honor that this is—
Mr. Hazelwood, can I follow? So you've got the order now, as you said, when the court decided to exercise its discretion, it then had to apply Apprendi. But I think, as I understand your position, the court is obligated to apply Apprendi. And so in that sense, it sort of strips the court of the discretion that Judge Wilkinson is rightly concerned about, that the statute ultimately allows the district courts, because the end of the limitations section of the statute says that nothing in this section shall be construed to require a court to reduce any sentence. But that doesn't seem to be, I mean, if we're applying the reach of our cases and we're here and we're obligated to do that, it seems as Judge Wilkinson has indicated that there is no longer any discretion, at least when it comes to an application of Apprendi.
Well, if I could answer that question in two ways. The first is, I think that the latter, as Your Honor was saying, is dictated by Collington. District courts have discretion. What they don't have is discretion to impose a sentence outside the statutory sentence range.
Which is to say they don't have discretion.
When application of Apprendi or application of the Fair Sentencing Act, statutory ranges would mean that
the authority for these sort of carve-outs.
Well, I think that's what this court
where do
did.
we get the authority? Why isn't the guidelines a carve-out? I mean, I can think of a number of carve-outs to the district court's discretion, and it bothers me that we'll be beginning now with carve-outs to the district court's discretion, and I don't see the statutory basis for any of that.
Well, I think what this court said in Collington is there is discretion, but it is an abuse of discretion to refuse to impose a reduced sentence when that is effectively a decision to maintain a sentence above the applicable statutory sentence.
No, but we're talking about a very specific statute, that this isn't just a normal abuse of discretion business. This is a discretion which is backed up by the fact that you cannot require a court to reduce any sentence pursuant to this section, and that's what you're doing.
Well, I think as this court held in Collington, the First Step Act made the Fair Sentencing Act statutory sentencing ranges retroactive. So it is an abuse of discretion to refuse to apply those statutory sentencing ranges and maintain a sentence that's now unlawful. It would be unlawful.
I'm still bumping up against that statute and against Dillon, and there's too much of that going on here. And I think we're wading into trouble. I'm very concerned about it. At any rate, I always like to give you the last word, Mr. Hazelwood. So please, you close.
Thank you, Your Honor. If I may, in light of your question, Judge Diaz, and your concerns, Judge Wilson, there is a narrower way that the court could address Mr. Slate's case specifically, which is, as I've said here, there's no dispute that the district court did exercise discretion, did impose a reduced sentence. So I would encourage the court to look at Collington, specifically the passage on page 357. Again, Collington was a case in which the district court had refused to impose any reduced sentence. And we've had our debate about the holding thing. What the panel said in Collington 357 was it would be error for a district court to choose to impose a reduced sentence, and in so doing impose a sentence, I believe they said, of 20 years and 1 day, which would exceed the statutory sentencing range. I think the panel was right that that was easier. The district court has already exercised discretion, is applying the fair sentencing.
Thank you, Mr. Hazelwood.
My apologies, Your Honor.
I said, thank you very much. I'm going to ask Judge King and Judge Diaz if they have any more questions for you. And if they do, we'll entertain those. But if they don't, we will go into our next case. Judge King, do you have any further questions?
I have none.
Judge Diaz?
I do not. Thank you.
All right. I would like to thank you both. Mr. Hazelwood, we very much appreciate your argument, and I understand that you are court appointed. Well, that makes us especially appreciative of the fine argument you've given. And Mr. Cook, I want to thank you. You always give a good, well-informed argument before this court, and we really appreciate yours too. So we thank you. We thank you both. Okay.
Thank you, Your Honor.
I'll ask the courtroom deputy to take leave of this.
Judge Wilkinson, it looks like counsel is ready to proceed.
All righty. Mr. Alfred, we'd be happy to hear from you in this second case.
Yes, sir.
Please proceed when you're ready.
So, yes, sir. Good morning. My name is Gregory Alford. I represent the appellants, Contrabest Construction and Plantation Point Homeowners Association. We are here because of the Erie Doctrine, essentially, and that the district court did not apply South Carolina's insurance law nor its damages law in light of the fact that there was a finding of prima facie bad faith. When bad faith exists, as this court respectfully has held in Smith v. Maryland Casual Company, 742, that second Fourth Circuit case in 1984, this court held that when there's some evidence of bad faith, a jury has to decide. Unfortunately, the district court kind of went with the hit Stonehenge finding, which was purely a contract or indemnity matter. And the finding was that under that line of cases, and it respectfully to the district court ignored his own finding of bad faith, which in his order affirming the magistrate, the district court said a jury should decide because there was a prima facie finding of bad faith. So with that background, it's interesting because South Carolina.
Mr. Alford, excuse me. So with respect to this prima facie finding of bad faith, that was done, or that decision was reached in the context of this question of privilege, right? And the scope of privilege. Isn't that right?
Respectfully, not exactly, Your Honor. The magistrate did a report, did the R&R. And as that came up, it certainly got its most focused in that context. But when that conduct was looked at, there was the finding of prima facie bad faith. And they went into an explanation. I'm happy to discuss it with the court if you'd like, of what.
Well, I guess what I'm getting at is, I mean, the district court could certainly change its mind about that finding and determine, based on the summary judgment record, that in fact there was no prima facie evidence of bad faith.
They could, Your Honor, but that did not occur in this case in either of the orders. That he never dealt with that.
But I had the same question as my colleague, and the broader question I have is that this circuit has been very emphatic in saying that a breach of contract action doesn't routinely turn into a tort, because people seek the contract in order to gain a certain predictability and certainty in their future commercial relationships. And if you turn breach of contract actions, even in the insurance context, into torts, the tort actions have wide open damages. They're much more wide open than contract actions. And if you have these bad faith actions going along all the time, premiums are going to rise sky high. They're going to go through the roof. And I just think that this court's historic position that breach of contracts are not torts, presumptively not torts, unless you have, as the district court pointed out, some very specific criteria that are met.
Yes, sir. I'm sorry.
No, I mean, it seems to me that you've got a lot of different hurdles to overcome and a lot of different criteria to overcome, but starting, this is the line in this court's precedents that said breach of contract actions are not presumptively tort actions.
And I would agree with the court, Your Honor. And in fact, Stonehenge looked at that. Stonehenge did an excellent job of looking at that. In the Stonehenge case, the court looked at it and a defense was raised, the prior knowledge defense. And the court said, you know what? That's not bad faith, because that was a valid, insurers have an absolute right to raise valid coverage defenses. The problem that the magistrate had, and the problem that the district court judge had, and frankly, the problem that we had throughout the case was, before this case started, was the insurance carrier, Mount Holly, took a position for years as the underlying coverage was eroding. Then they changed that position when the underlying coverage got eroded, and there's evidence in the record of that. In fact, that was the ultimate finding of the district court, and he says, ultimately, the court recognizes competing inferences and competing evidence may win the day. The term prima facie, sufficient evidence, has been introduced to warrant submission to the jury of the issue which it's directed. The problem that the court had, and I agree with you, Judge, we can't open the floodgates. I'm not advocating opening the floodgates.
Well, but that's the very thing you're trying to do.
Respectfully, Your Honor, I'm not. What I'm suggesting,
because you're proceeding in the face of a no action clause, and that is that the insurer's obligation to pay must proceed from a judgment or a settlement. And this is the whole no action clause, and it's found in a great many excess insurance policies, because many times an excess insurer is not on the ground floor when settlements and the like are reached. And so
Yes, sir.
what an excess insurer tries to do very often is say, look, if you're going to go after us, you at least have to tell us what the trial judgment is or what the settlement amount is. But we have to know what we're supposed to pay before you try to put us on the hook for not paying whatever it is.
And I could not agree with you more, Your Honor. In fact, that's where the district court and the magistrate found the bad faith, was in that back and forth between the insured and Mount Holly. That was going back and forth. In fact, up to the very day of trial, a letter came from Mount Holly the very day of trial saying, don't you guys try to settle. I mean, they participated only to
No,
say.
but I none of this is convincing me that you're not trying to vitiate the effect of these no action clauses in excess insurance policies. And the effect of that would be absolutely huge.
Well, and Your Honor, I'm not trying to break down that wall. And I'm not asking the court to do that on the facts of this case. I would submit to you, this is a fact-specific matter where you had exhaustion of all the underlying coverage, and Mount Holly was aware of the exhaustion.
Well, what were they supposed to do? They didn't know what the judgment was. There was no judgment that told them how much they were supposed to pay. There was no settlement that told them how much they were supposed to pay.
They did.
They were supposed to get into it. They were supposed to be reached with their consent. It never was reached with any consent, as far as they still haven't been informed of what their obligations even are.
I'm sorry, Your Honor, respectfully, the record, they were involved in the conversation the entire time and communicating back and forth up until the very day of trial. At trial, a settlement was reached. They were offered the opportunity and they failed to participate. And let me just say this, Your Honor, I respectfully, South Carolina law in the In re Mount Holly opinion, and I know that was about the attorney-client issue, but in the context, they said the bad faith context of South Carolina, the tort and the contract claim were recognized in South Carolina. So I'm not asking the Fourth Circuit to open the floodgates all over the United States, but South Carolina is very insured, and this is a fact-specific case. It wasn't, and Your Honor, I would respectfully disagree with you that they were not informed of what was going on up to the minute. And
you know, whenever somebody's going against a considerable body of law, they always refer to it as a very fact-specific case.
But
I don't blame you, but that doesn't lessen for me the significance of what you're trying to do.
But Your Honor, what I'm really not doing is that, because I would like for the court to go with the Smith opinion that came from this court because of that fact difference. Both in Hitt and Stonehenge, I understand the court's policy concerns. I truly do. But consider this for a moment. In this case, there's a prima facie finding of bad faith conduct on the way the claim was handled, the letters that were coming in, and the things that they were saying, and how they changed their positions from while their policies were not, quote, on the front line. And that's out of one of their emails. We need something better because our policies are now on the front line. When a decision came down. And this will be the first time this court has looked at this after Crossman, really. But what I'm saying to you is, if there's a finding of bad faith, I don't think every case should be a bad faith case. If a carrier has a perfect right to say, especially in a no action case, I'm not doing anything. That's the point.
How did you suffer, counsel, how did you suffer any damages on this? Because the district court made a point of stating the Hornbook proposition of South Carolina law, which is that you have to suffer some kind of consequential damages. And you made this voluntary confession of judgment, but you know, that didn't cost you a single penny.
And Your Honor, what I would say is
because you were bankrupt or defunct. So you confessed, you voluntarily confessed to judgment, but you confess to a judgment you would never have to pay.
If I may, Your Honor.
That's really odd.
Well, may I tell you what happens to the entities that are in that position? They're trying, and even under Stonehenge, Your Honor, this case should go back under the contract claim. simply because $3.3 million was paid because this defunct entity had purchased insurance. People purchase insurance. It's an asset. And I think what the court is saying, I understand.
Did your client pay anything?
The insurance paid premiums for insurance.
Did your clients pay anything as a result of the confession of judgment?
They didn't have anything to pay. They didn't have any, and I think that's where the court's not applying South Carolina law respectfully, because, and we cited the law in our memorandum. South Carolina law says that the judgment.
Well, this is only one of many problems with your particular position. And the district judge is plenty familiar with South Carolina law. He's seen a lot of these cases come down the pipe. With all respect to you, this one seemed to me to be particularly problematic on the different fronts that I've tried to identify.
Your Honor, could I address your damages question briefly? One of the fundamental tenets in South Carolina law, and it's been cited by the district court, is where a wrongdoer creates a situation that makes proof of exact amount of damages difficult, juries are allowed to act upon probable and inferential as well as direct and positive proof. The district court adopted.
But Mr. Alford, you don't get to a jury unless you have some evidence of damage. I mean, it's true that a jury can infer from the facts the full extent of the damages, and ultimately a damage award is in the discretion of the jury. But there's got to be some evidence of damage. Although I will say this, I wonder, and this wasn't raised by anybody. In most jurisdictions, and I think South Carolina is among them, would allow an award of nominal damages, even in the absence of actual damages, and then allow the case to go to a jury on the question of punitive damages. But that never came up, and I wonder what your position is about that.
Well, and that's exactly correct, Your Honor. In fact, there are a number of things that could be construed as damages under South Carolina law. And we talked to the court about it. And considering we have a much relaxed.
Did you talk to the court about nominal damages?
Yes, sir. We talked on the record about all types of different damages. And in fact, one of the positions that we discussed with them was, I'm sorry, Your Honor, just one second, was that the damages are, just bear with me 1 second, Your Honor. You've got reputational damage. The contravest entities still exist, and the gentleman testified, we don't want a judgment against us. We never had one. We'd like it taken. In construction cases, it's very. But
it wasn't, Mr. Alford, it wasn't a judgment against them personally. It was, as Judge Wilkinson said, a judgment against a defunct corporate entity. I don't see how that would have any kind of reputational impact.
Well, Your Honor, respectfully, because they carried on the name in their next, that's what they'll do. Contravest Inc., Contravest LLC, and they carry on, because what happens is once they're out of insurance, once their insurance assets are depleted, and I want to address one thing with the court. Please don't confuse, and I'm afraid this happens a lot. Please don't confuse never intending to pay anything with the inability to pay. They purchased insurance. They have a right to it. You talk about damages, and we addressed this with the court. They paid premiums. They got nothing for them. Hundreds of thousands of dollars of premiums for these $10 million policies. They paid an attorney to fight for coverage, which they never got. They nominal damages and punitive damages. And I think that's the difference I'm trying to express to this court. South Carolina law says, and this court has recognized in the Smith-Maryland cash case, if there's some bad faith, the jury gets to decide. Nominal damage is $1.
All right, we thank you, because we've been over that. And the question is whether there was a tribal issue under these facts or not. And but we appreciate it very much. And you have some, I'm going to ask my colleagues if they have questions. And you also have reserved some time for rebuttal, Mr. Alford, which you will have. Judge King, do you have some questions you'd like to ask of Mr. Alford?
I do not, Your Honor.
Judge Diaz?
No, sir. Thank you.
All right. Thank you very much, Mr. Alford. And now let's, we'll look forward to hearing from Mr. Brown.
Thank you, Your Honor. May it please the court, Mitch Brown from Mount Holly Insurance. this is an excess policy situation in which there is no duty to defend. That is expressly stated in this particular excess policy. Some excess policies, as the court knows, will say there's a duty to defend once there's an exhaustion or things like that. Other excess policies, like this one, simply say there is no duty to defend, period, and there's not. That has been upheld by various courts. This exact provision has been upheld by various courts, and it's not challenged here. In addition, as Judge Wilkinson pointed out, there's a no action provision in this case. South Carolina Supreme Court, in the case called Sexton, which is cited in our briefs, has specifically upheld that provision, which requires that there be a judgment after an actual trial, which did not occur here, or a settlement in which Mount Holly has the option to participate, which it had no, in which Mount Holly agrees, which it did not agree.
Mr. Brown,
yeah,
can you hear me? Sorry.
Yes, sir.
Judge Wilkinson, I don't see Mr. Alford on the screen anymore, and I wonder if he fell off.
Judge Diaz, I'm showing he's still connected, but muted his video. I've asked to, yep, there he is.
Oh,
Thank you.
got it. Okay. Never mind, sorry.
No problem. The contract claims, and here, as the court knows, the appeal here relates only to the bad faith order of Judge Norton. He's already ruled that there is no basis for the contract claims to go forward. He's already ruled against the unjust enrichment claim, and there's no appeal as to that either. So what we're left with is the argument of counsel that the implied covenant of good faith standing by itself somehow makes Mount Holly liable to pay this confession of judgment for $9 million that Mount Holly did not agree to. It does not have any duty to pay that for numerous reasons. My opponent tries to characterize this as some open-ended jury question that the jury can just come in and decide whatever damages they would like to assess based on a prima facie determination in a discovery order, which has since been retracted by Judge Norton. As Judge Diaz, I think, was noting, and the judge has all discretion to withdraw that prima facie or to simply disagree ultimately at the summary judgment stage with any finding of bad faith, which he did. In addition, the court found that there were no damages here. He gave the opposing counsel additional opportunities to present anything to the court that there was some damage of any kind whatsoever. And the only thing that the plaintiff presented was the confession of judgment. And the plaintiff said this confession of judgment is the damage. That was the only argument advanced. The confession of judgment cannot be the damage because of the Stonehenge case and the Hitt versus Cox case. The confession of judgment is really, in essence, an attempt to set up the excess carrier, and really no less than that. It was not agreed to by Mount Holly. Mount Holly, in fact, never even got an opportunity to examine the proposed confession before it was entered into.
Mr. Brown, can I ask a question about the damages issue, which I asked Mr. Alford, and because I think you would know a lot more about South Carolina law than I do, but is it correct that a case can't go to the jury in South Carolina on nominal damages alone, or do you have to make a showing of actual damages to get to a jury?
Your Honor, in some cases, like a trespass case, you would have a nominal damage implied by law that would take that element and satisfy that element. In a case where the only thing that you're asserting, which is what, despite counsel's statement to the contrary, he's doing, is an implied covenant of good faith in the absence of any deprival of any express contract benefit. The Tadlock versus Maryland Casualty Company case says you must prove consequential damages. That's what it requires. They didn't prove any consequential damages. They proved zero damages. And the only thing they continued to bring up was this very unfair confession of judgment. And they pointed to that. They raised various straw men, frankly, arguments like insolvent entities have a right to insurance. Of course they do. I mean, that's not the point. What the point here, Your Honor, is that in a setting where there were multiple defenses in this construction defect litigation, statute of limitations, statute of repose, the scope of repair damages was like viewed as a $1.5 million scope of repair by all of the collective defendants, whereas the plaintiff viewed it as a $30 million case. Instead of going to the jury verdict and having an actual judgment after a trial, what happened here is the primary insurance companies and Contravest and the homeowner association all got together and they apportioned some monies between themselves. And then they said, let's do a confession of judgment where the only party that has to pay this money is Mount Holly Insurance, the excess carrier.
Mr. Brown, to follow up on Judge Diaz's good question with respect to the nominal damages, first of all, I don't think they were pled here, but I think that, as I understand state law on this, it depends on the type of case. And you would have as I think Judge Diaz alluded to earlier, a better case that a nominal damage in a reputational damage setting, and some instance where intangible damage was still damage you can understand. You can sometimes nominal or intangible damage can start to be damaged. In the construction industry, it's different. What you guys are interested in is the bottom line, and you deal in pretty big sums. And nominal damages just isn't the kind of issue in a construction tussle as it is in some other instances where there's an imbalance of power, or where somebody is being hurt in an intangible but yet still meaningful way. But I would think construction, you folks deal with big sums. I don't think you're interested in $1 amounts, but a different kind of case might present a different sort of question, don't you think?
Yes, Your Honor, I do. Potentially, it might. Not here. Here, the plaintiff was afforded each and every opportunity, multiple opportunities by the district judge to specify what his damages were. And the only thing he pointed to was the confession of judgment, which, as I've stated, is also unenforceable against Mount Holly. That's the other kind of, it's related but separate reason why this confession of judgment cannot be made payable by in favor of the plaintiff, is because of the Stonehenge case, and it's essentially a setup of the excess carrier.
Mr. Brown, I'm wondering if it wouldn't be best now for me to ask my fine colleagues if they had some questions for you. Otherwise, I think we understand your argument, and we have both of them in the briefs. But I'm going to ask my friend Judge King if he has some questions for you. Judge King?
I'm fine. Thank you, Your Honor.
All right, I'm going to ask Judge Diaz if he has some questions for you at this point.
I do not. Thank you.
All right, well, I have no further questions for you either.
Thank you, Your Honor.
We thank you very much. And Mr. Alford, you have some time that to rebut what Mr. Brown has said, and we'd be happy to hear from you on that.
I'm sorry, Your Honor, I had to unmute the microphone. I probably need all the time I could get based on the first round. But I'll just say this, first things first. The problem with what's happening here, and you're right, we do deal in big dollars. In this case, over $14 million were paid from the various subcontractors. And I will say this, it isn't the fact that the dollar amount of the judgment that Mount Holly's liable for. What they're liable for is the fact that they're insured. They acted in bad faith. I mean, the court found they did, and the court has never taken that finding back anywhere in the record. They acted in bad faith and made them sign a judgment. I mean, they have a choice. Otherwise, all of the entities would have had to go to trial. Secondly, even under Stonehenge, Your Honor, $3.3 million was paid on behalf of by not just or underlying carriers, but also two excess carriers. Crum & Forster paid as an excess to generate that $3.3 million. So under Stonehenge, it should go back for some amount of allocation, and that really should be done under the Crossman analysis, which directly says that it either falls at footnote 15 to Crossman should be important to this court, because what it says is that it falls if in the years, the way the years go in the coverage, if there's a year where the underlying coverage is exhausted, it either falls on the excess carrier, or if there's no excess insurance, falls on the insured. Well, guess what? There's $20 million, $10 million a year of excess. And the court asked this question, well, people are going to be giving away money, and I agree with you. You shouldn't be able to set up carriers to sign judgments. That defendant, not with my help, did what they thought was prudent to get out of the case. At that point, the case is, their case is done, except for this piece, because what did they buy from Mount Holly? The problem with what this court, respectfully, the problem with the position where we're going to end up policy-wise, okay, in the big picture is this decision encourages excess carriers with no action clauses to act in bad faith, because they're getting away with something that South Carolina law says you cannot do. And respectfully, under the Erie Doctrine, this court can't.
So the South Carolina courts have upheld these no action clauses, Mr. Alford.
Yes, sir, they have, but not where there's been bad faith, not where there's been a prima facie finding of bad faith. I mean,
but that's assuming the conclusion. I mean, you were pointing to these no action clauses as some kind of prima facie evidence of bad faith, and the South Carolina courts have upheld them.
I'm all for a no action clause, Your Honor. I think it's legitimate, but that doesn't remove the obligations in statute and in the Tiger River Doctrine, which is still law in South Carolina, doesn't remove the obligation for the carrier to at least participate in good faith, or at least play along. They don't have to defend, they don't have to indemnify. They're allowed to have their contractual defenses. I'm not against a no action clause. What I'm against, and what we're advocating against here, is a policy that would allow a no action clause to allow bad faith conduct to occur. It's fine if they have a no action clause and say, hey, we're not getting involved and we're not paying. But what you have here is a prima facie finding of bad faith early in the case, and they did. I mean, read the letters.
Hey, well, tell me again what that is premised on, Mr. Alford. What the bad faith finding is premised on?
Your Honor, what happens with these, if I may, it's going to take a second, but what happens with these construction claims is under Crossman, which is our paradigm to resolve progressive damage claims. The South Carolina Court adopted Crossman. So if there's 10 years of coverage, they'll say, okay, year 1, year 2, year 3, year 4, year 5, and you go down the list. In the year that this coverage got exhausted because the company kept getting sued, okay? And finally, when they only had this little bit of coverage left, 2 years got exhausted, and there's an email. There's an email from one of the adjusters to another adjuster saying, well, we better have more than this other provision to rely on, because our policies are going to be on the front line. Up until that time, over the series of lawsuits that had taken place, to erode 13 years, 14 years of substantial insurance coverage, underlying coverage. You're talking millions in the underlying years were eroded. When they found out all of the years when their policies weren't even close to being accessed, they did a follow form letter saying, okay, we got it. You know, we received notice of the suit. Here's our defense, you know.
If you have these sorts of problems, people think that, oh, you have to reform the entire insurance industry with one of these bad faith lawsuits. But, you know, there's always the insurance commissioner and there's always the state legislature to go, and if you see some sort of systemic problem, it's not clear to me that we're the ones to be particularly in a federal court on trying to reform South Carolina law.
And Your Honor, I'm not asking you to. They changed their position and started asserting new defenses that they admitted in their pleadings later were not correct. And that's what offended the magistrate, and that's what offended in her findings, because that was the bad faith. And I'm not asking you to reform the system.
We're looking at the district court's judgment, and in any event, Mr. Alford, your time has expired, and I always like to give my colleagues a chance to ask you any questions if they have. Judge King, do you have some questions?
I'm satisfied, Your Honor.
All right. Judge Diaz, are you okay if you have some questions?
I do not have further questions. Thank you.
All right. Mr. Alford and Mr. Brown, I want to thank you both for your arguments. I'm sorry we can't come down and shake your hands the way the Fourth Circuit traditionally does, but we regret and you understand why that's so.
Sir.
So
Thank you.
Wish you both a nice afternoon and thank you so much. And I'll ask a courtroom deputy, please, to adjourn court.
Yes, sir. Thank you, Your Honor.
Thank you, Your Honor.
This honorable court stands adjourned. God save the United States and this honorable court.